In this video, we're going to talk about the important contract law case of White and Carter and McGregor. In this case, White and Carter had a contractual relationship with McGregor where White and Carter would display advertisements on rubbish bins. When their contract was about to end, McGregor's employee had asked White and Carter to renew their contract for a further few years in order to supply advertisements. When the company found out, McGregor promptly informed White and Carter that this was a mistake, and in fact, McGregor did not want to renew the contract. In this case, therefore, McGregor is the party in breach, and White and Carter, one might say, is the innocent party or the victim. However, White and Carter refused to terminate the order and went ahead with displaying the advertisements anyway. White and Carter then sued McGregor for the agreed price. Now note, this is a debt claim, i.e. an action for an agreed sum that was contractually agreed on between the parties. This is not a damages claim for loss. The House of Lords held by a bare majority that White and Carter was indeed entitled to keep this contract alive and recover the agreed price from McGregor. It had no obligation to accept McGregor's breach and terminate the contract. Lord Hodson, in the case, reiterated the important principle that an innocent party has a choice to elect either to affirm the contract or to terminate the contract when the counterparty had repudiated the contract by breach. Lord Hodson stated that there is no duty on a party to a subsisting contract to vary the contract at the behest of the other party so as to deprive themselves of the benefit given to them by the contract. To hold otherwise would be to introduce a novel equitable doctrine that a party was not to be held to their contract unless the court in a given instance thought it was reasonable to do so. It would, in fact, make an action for debt a claim for a discretionary remedy. This would introduce an uncertainty into the field of contract, which appears to be unsupported by authority. So we can see here the anxieties of Lord Hodson if we were to say that White and Carter had not been entitled to keep the contract alive. And we can see the wisdom in this because an action for the agreed sum, as will also later be elaborated on, can usually be made through the summary judgments procedure at quite minimal cost and time. If, however, an action of the agreed sum was dependent on whether the innocent party's decision to affirm the contract and to perform under the contract was to some standard reasonable, that would deprive the debt procedure of its simplicity. Now, whilst Lord Hodson was more emphatic about this principle and made no exception to the rule, Lord Reid was a bit more flexible. Whilst Lord Reid agreed with Lord Hodson that an innocent party does have the choice to affirm or terminate the contract where a counterparty has committed a repudiatory breach, there are two circumstances where it would be unreasonable for the innocent party to keep the contract alive and not to terminate the contract and later claim an action for the agreed sum. The first circumstance is known as the cooperation exception. Here, Lord Reid states that in most cases, by refusing cooperation, the party in breach can compel the innocent party to restrict their claim to damages. In other words, where the party in breach can withhold some element of cooperation, the innocent party can no longer perform. And if they cannot perform, they cannot then obviously claim for the agreed price because they had not discharged their obligations under the contract. Therefore, the innocent party is limited to only claiming in damages and not in debt. We can see this through an example where a taxi company hires a driver and agrees to supply the driver their own company taxi car. If the taxi company chooses to repudiate the contract and does not give the driver the car, The taxi driver obviously cannot perform under the contract because the taxi driver has no car, so the driver does not have a debt claim, but may have a claim for damages, subject to more complex proceedings, of course, as it would require cooperation by the other party, i.e., by the taxi company. However, the peculiarity of White and Carter and McGregor was that the pursuers could completely fulfill the contract without any cooperation of the defender. In other words, the posting of advertisements on rubbish bins by White and Carter is not contingent at all on the cooperation on the part of McGregor. White and Carter can simply do it without needing any cooperation from McGregor. So, in these circumstances, White and Carter can bring a debt claim after it had performed its obligation. This has the benefit, as mentioned, of having to go through the summary judgment without needing a full and complete trial, thereby saving the parties a lot of time and money. Now, Lord Reid's second exception is a bit more interesting. It is known as the legitimate interest exception. In his speech, he states, "It may well be that if it can be shown that a person has no legitimate interest, financial or otherwise, in performing the contract rather than claiming damages, he ought not to be allowed to saddle the other party with an additional burden with no benefit to himself. If a party has no interest to enforce a stipulation, here the party is the innocent party cannot generally enforce it. So it might be said that if a party has no interest to insist on a particular remedy, he ought not to be allowed to insist on it. This means that if in the case of White and Carter and McGregor, the court held that White and Carter did not in fact have a legitimate interest in making those advertisements on the bins, then White and Carter's decision to keep the contract alive and then claim for an action for the agreed sum would be unreasonable. Now, the term legitimate interest here is obviously a bit open-ended, and it has been interpreted by the later courts in various other decisions. Here we can see that Lord Reid had in mind a very broad notion of the concept, because he states explicitly that a legitimate interest is not confined to a financial interest. However, the creation of these two exceptions to the general rule that an innocent party to a breach of contract has an unfettered power to elect between affirmation or termination was not gone unopposed. Indeed, Lord Keith gave a dissenting speech in White and Carter and McGregor. He gives an example where it would seem that a man who has contracted to go to Hong Kong at his own expense and make a report in return for remuneration of £10,000, and who, before the date fixed for the start of the journey, is informed by the other party that he has cancelled or repudiated the contract, and then he goes and set off for Hong Kong anyway to produce his report in order to claim in debt the stipulated sum. It seems that he would be entitled to such a claim. Lord Keith states that such a result is not, in my opinion, in accordance with principle or authority, and cuts across the rule that where one party is in breach of contract, the other must take steps to minimize the loss sustained by the breach. Now, immediately it should be noted that Lord Keith's mitigation rule, as he mentioned, is very much a rule on damages. However, this is not a damages claim, but a debt claim. So query whether the principles of mitigation have the same application towards debt claims in the same way as it applies to damages claims. In conclusion, the principle in White and Carter and McGregor may be summarized as follows. Where one party to a contract, let's call them B, for contract breaker, has committed a repudiatory breach, the other party, let's call them V, can elect to affirm or to terminate the contract, as Lord Hodson stated. If V chooses to keep the contract alive and continues to perform, V may later recover the agreed contract price from B, provided that, firstly, V's performance does not depend on B's cooperation, and V has a legitimate interest in performing the contract, as opposed to merely claiming damages. The latter two provisos being the exceptions that Lord Reid had stipulated.